Consumer alert for you this morning. We have heard time and time again about tenants having problems with their landlords. So what do you do if there is a problem with your place and your landlord will not help you? We are here to help you, and we have a guy that knows what to do. So this is Adam Thorson. He's a local attorney with Jacksonville Area Legal Aid. I know that you've been with the organization since 2009, helping people every single day. So good morning to you. Appreciate you being on this morning.
That's right. Thank you.
And I know that we get so many calls. We do, Adam. So many people saying, my landlord is not being fair to me. And it's a difficult situation for people. What's your biggest advice? I mean, when do you have to take it to the next level, get an attorney, consider legal action?
Right. You know, I think the biggest piece of advice I could give a tenant, if you're having issues with your landlord, probably try to communicate in writing, particularly if you're having problems with conditions at your rental unit. I think you also want to involve the city. So the city has a municipal code compliance division. And if you're having problems with a leaky roof, or you have rodents, or you have some other issues, if you call in code enforcement, the city can come inspect, and that gives you a little bit more leverage with your landlord.
Okay, sometimes we hear about landlords that don't want to give a written lease.
That's right.
And they just want to do it month to month and maybe cash only. What do you do in that situation?
Yes, you know, I think cash only can be a little bit dangerous because you may not have proof that you've paid your rent. Believe it or not, there's a lot of landlords that will take advantage of that. You know, month-to-month tenancy can actually be good if you need that flexibility. So you're not locked in to a 12-month lease like you ordinarily would be. So if you might need to move on short notice, maybe a month-to-month tenancy is good for you. But generally speaking, I think most tenants wouldn't find that advantageous because they want that stability of a year-long lease.
For a lot of people, times are tough. And they have that security deposit, and they need it to help move.
That's right.
Okay? So say their lease is up in May. They're trying to go somewhere else. They ask for their security deposit back. They're not able to get it.
Right. So that's one of our most common questions. Can I have my deposit back before I move so I can help with relocation expenses? Or maybe I'm a little short with rent this month, and I'd like my landlord to use my deposit towards my rent. Well, unfortunately, that's not what the law says. That's not what most leases say. And so a landlord is not supposed to use that deposit for anything until you actually vacate. So when you vacate your unit, the landlord either has 15 days to return the deposit to you in full, or they've got 30 days to let you know, hey, tenant, there was some damages. I'm going to make a claim on your deposit. Here's that written notice. So the best tip I can give for that, if you're moving out of a unit, is make sure and give your landlord a good forwarding address, because that's where those written notices have to come. And if you don't give that forwarding address, the landlord's going to send it to the last known address, which is the property you just moved out from, and you may miss important information.
Right. What about email nowadays?
You know, I think email...
Does that count as being written notification?
No, they actually need to send it certified mail, so it has to be physical letter.
Okay, and then I know that Jacksonville Area Legal Aid also helps a lot of people with ADA compliance, with issues there. We do have people that say, I'm in a wheelchair, I'm disabled, I'm not able to get into my apartment or my rental home or whatever it is like I used to. Right. When does that become a big issue? Because I know that there's so many rights that people with disabilities have.
That's exactly right. So a quick plug, April is Fair Housing Month, and so that's something that we're really trying to publicize, and there's a federal law called the Fair Housing Act that landlords have to abide by. So if you're a person with a disability, let's say you move into a rental unit and you figure out, okay, maybe this door isn't wide enough, I can't get my wheelchair through, or maybe I need a ramp for ease of access, that's something that the Fair Housing Act says that your landlord needs to allow you to do. But one of the common misconceptions is the landlord is not required to pay for those modifications.
Okay.
It's called a reasonable modification.
Right.
So the tenant would actually have to pay for that and have someone do it, but under the Fair Housing Act, the landlord is supposed to allow you to make that modification to the rental property so you can access it with your disability.
Hey, thanks for making it easy. Thanks for all that helpful information. And Adam Thorson, we appreciate you coming on. Appreciate what you do in the community.